We will go on the record in the matter 26 CF37, State of Wisconsin versus Shane Cook. The state appears through District Attorney Kevin Schmidt in person. We have James McLaughlin, Defense Counsel, in person. Mr. Cook is in person in custody. We're set today for two matters. One is a preliminary hearing and one is a bond modification request. The court has in front of it a signed waiver of right to a preliminary hearing document. Do you recognize this document, Mr. Cook?
Yes, ma'am. Yes, Your Honor.
Did your attorney go over this document with you thoroughly,
Yes, Your Honor.
essentially word for word,
Yes, Your Honor.
and you understand everything completely?
Yes, Your Honor.
Did you sign that document?
Yes, Your Honor.
You understand, once you waive the right to a preliminary hearing, it is forever and you cannot get it back?
Yes, Your Honor.
Has anyone made any threats or any promises to you for you to waive your right to a preliminary hearing?
No, Your Honor.
You're doing so freely and intelligently, telling the court you fully understand what you're doing
Yes, Your Honor.
and voluntarily.
Yes, Your Honor.
I will find that you are freely, intelligently, and voluntarily waiving the right to a preliminary hearing. I will find probable cause and bind the matter over. Information, Mr. Schmidt,
I filed the information. It mirrors the criminal complaint.
proceed with an arraignment or set for another date, Mr. McLaughlin.
I would prefer another date, Your Honor, because the issue of, I have not reviewed with him, for example, the issue of judicial substitution, which is an arraignment deadline. So therefore, if the court would allow, I would be more comfortable with a separate date. Let me get in my calendar, please.
You can have tomorrow morning
Tomorrow morning would be fine.
and 10 o'clock, or how about 10:30?
Ten 10:30 tomorrow would be
One
fine.
sec before we schedule out.
Well, yes, that would be fine.
Okay, yeah, that works. Sorry, I was thinking of a different day.
Okay, 10:30 tomorrow morning. Sounds good. Bond modification request. Would you like to argue it today or tomorrow?
I would prefer to argue it this morning, Your Honor. It had been noticed for today.
All right, then you may continue.
Your Honor, the defense, first of all, would like to acknowledge the seriousness of your charge and not to deny that. However, the defense believes that the defendant has substantial, essentially lifelong ties to the community. He is dutifully employed Ms. Kara Boyer, who is a longstanding Burnett County employer for over 25 years. She's owned the Dairy Queen restaurant chain, one of which is his here in Siren. And she is here to state, I will just make an offer of proof without testimony unless requested, that she is willing to not only provide transport for Mr. Cook to ensure his appearance for court appearances, but also she and her brother Kent are going to be willing to post up to $3,000 cash surety on his behalf to ensure his appearance. Again, I believe that $3,000 is a substantial sum of money. Mr. Cook has a substantive, reliable employment relationship with the Boyers. They are obviously longstanding, relevant community members. Ms. Boyer and I spoke of the fact that she's involved with the recovery community. Obviously, absolute sobriety will be a condition of any bond that Mr. Cook would have to abide by, and Ms. Boyer is willing to assist Mr. Cook in his recovery efforts, assuming arguendo that those are necessary. So I believe, Your Honor, that defense acknowledges the seriousness of the offense, but given the standing of a substantial community member, as well as Mr. Cook's, as I've recited in my motion papers, his relatively modest prior criminal conviction history. As far as Wisconsin CCAP goes, I don't have access to international and national database, but he has 2 prior misdemeanor convictions according to Wisconsin CCAP, and therefore does not have at age 46, does not have a long-standing substantive criminal record. Therefore, Your Honor, for these foregoing reasons, I believe that the motion to modify is based on new factors that were not entirely in front of the court at the time of the original setting of bond. Thank you.
All right, thank you. Mr. Schmidt?
The state takes no position on this.
All right. Well, Miss Kara goes back even further than the Dairy Queen to the fancy freeze. And that's what I remember when I was growing up. And then I believe the Frederick Dairy Queen and then the Siren Dairy Queen. She is a respected member of our community. Mr. Cook, because she is willing to back you, the court is willing to amend bond to the 3,000 cash with the same conditions. No driving. You don't have a driver's license. And you've been working on getting that driver's license, and you have to continue to work at getting that driver's license. And so based upon that, and because you do have the support, don't let her down.
Oh, I won't.
Let the community down. Don't let this court down. So the absolute sobriety, those same conditions will remain in effect. You're coming back tomorrow. We'll go from there and we'll see what's happening with the case. So the court will amend the bond at this time. I am going to, as a condition in the bond, that someone, I don't know if Ms. Boyer, are you going to be the one solely responsible for ensuring that he gets to court?
I will pick him up. You said tomorrow at 10:30.
Yes.
I have one question to that. I have to have my mom at the United Hospital tomorrow. And Canton and I will be leaving around noon. We have to be there at 2 o'clock.
It'll be a 5-minute hearing.
Then we'll be fine.
Yeah, it won't be too long at all.
And for the clerk's record, Your Honor, I'll give his address if that would be of benefit. The address I have is 7354 Main Street East, apartment 16 in Webster, Wisconsin, 54893.
Mr. Cook was just recently in front of the court for other matters. I'm aware of his address.
I just wanted to, in case that it wasn't known by the clerk, Your Honor, pardon me.
That's why I stressed the no driving without a driver's license.
Yes, Your Honor.
All right, okay, thank you. We'll see you tomorrow. We're adjourned.
I'll see you tomorrow. I'll be early. You be a little bit early, okay?
So tomorrow here at 10:30, right?
10:15 for you.
Okay, not a problem.
Thank you.
Court gate. Hard to get through. We will go on the record in the matter 21 CM 112, State of Wisconsin versus Angie Jones. The state appears through District Attorney Kevin Schmidt in person. Ms. Jones appears in person without counsel. We're set here today in this matter. It's a status conference, but you were here at the initial appearance. This is a burial case. And an offer was made to plead to the charge, I believe, with the lowest possible guidelines and to deem the refusal as reasonable.
That's correct. And dismissing the reading and the resisting.
All right. And so Ms. Jones, you were going to think about that. I believe I explained to you what it meant if you were going to enter a plea and all of that. Have you had an opportunity to think about it and to talk to people if you wished, even an attorney?
I did have some time to think about it, and I made an attempt to, two attempts to contact the district attorney's office to see if there could be some minor alterations to it, but that
Were you able to speak with them?
no, ma'am.
All right. So what I'm going to do here is this is the district attorney. He's the one who runs the office. You can have some time. I'm going to adjourn the hearing just momentarily, give you some time to talk to Mr. Schmidt. He can't give you any legal advice. He can only tell you what the law is and what the offer would mean if accepted, if you reach an agreement. But he can't give you advice. He can't give you, you should do this, you should do that, you should do anything. He can only be straight with you, okay?
I understand that completely, and I did do a lot of research. I understand that defending yourself is highly unrecommended, but I did put forth a lot of effort and time to make sure that I wasn't wasting anybody's time.
And I appreciate that. So I'm going to briefly adjourn, and you and Mr. Schmidt, you can either talk here, you can step out to the hall if you wish to have a more private conversation. But so we'll adjourn, and now you can go have a talk.
Thank you.
And here we go. Things are getting real for Tyler Wilson. He already skipped out on his last appearance, which led to a warrant. The judge isn't playing around anymore. She literally puts him under oath right there and then drops the P word. Perjury. This is a civil case involving the Cubbyhole LLC, but the stakes just turn criminal. When the judge warns you that lying could lead to contempt or prison time, the room gets very quiet. Wilson is clearly feeling the heat, as he showed up without the documents he was ordered to bring months ago. It's a bold move, or a very disorganized one. Would you show up to a hearing empty-handed after a warrant was issued for your arrest? The audacity here is through the roof. Let's see how he handles the pressure of the supplemental examination without his paperwork.
We will go on the record in the matter 25FJ08, the Cubbyhole LLC et al. Versus Tyler Wilson. We have Mr. Wilson present here today in person in court. We also have Davis Sullivan, counsel for the Cubbyhole, present today in court. We're here for a supplemental examination. Mr. Wilson failed to appear at the last examination. The court issued a warrant for his arrest. He did contact the court and did affirm to the court that he will appear here today, and he has done so, so the warrant was quashed. Mr. Wilson, can you please raise your right hand?
Sure.
Do you swear that you're going to tell the truth, the whole truth, and nothing but the truth, and answer Mr. Sullivan's questions exactly with all honesty and truthfulness?
Yes.
All right, thank you. So Mr. Sullivan, you have the ability to have your supplemental examination. You can go in our attorney room and do that if you wish to do that. I have placed him under oath, and so all of the answers that he provides you must be truthful. If they are not, you could face not only contempt of court, but perjury. Okay, Mr. Wilson? So it's very important you tell the truth and you answer all things truthfully. Anything further, at least right now, Mr. Sullivan?
Just a few things, Your Honor. Included in the initial supplemental exam order that was served on Mr. Wilson back in September, there was a number of document requests. I would ask that the court sort of reorder Mr. Wilson to produce all the documents that were previously ordered. I have copies of the original order with me here that I can provide to the court and to Mr. Wilson. It also occurs to me that as we're talking, I might identify a few more specific requests. The original requests are sort of broad because I didn't know what I was talking about yet. So if it's all right with you, I'd like the ability to both sort of reissue those kind of blanket requests and also order Mr. Wilson to produce all of any specific document that I ask for within, say, 2 weeks from today.
All right. And so, Mr. Wilson, when you were originally served the first matter for this supplemental examination, there was a list of all the documents that Mr. Sullivan was asking for. Did you bring any of those documents with you today?
No, ma'am.
Okay. And so the court is now on the record. I'm ordering you to provide those documents 2 weeks from today, which would mean it would be by May 5th. To have all of those documents provided to Mr. Sullivan. Mr. Sullivan will provide you another copy of the documents that he is requesting. And Mr. Sullivan, is that in my file or do I need to now place it in my file?
I don't believe you issued that order, Your Honor. It was Commissioner Benson that did. I happen to have I have an extra copy of it if you'd like to take a look at it.
Does it have a stamp up there that says document number or something?
I don't believe so. Let me check. No, it does not.
All right. So then what I'm going to need is for you to file that with the court as well, so I know what I am ordering him to provide.
Okay.
And then upon receipt of those documents, Mr. Sullivan, I am ordering that you provide an update to the court, letting the court know that he has complied or he has not complied. If you do not comply, Mr. Wilson, that means the court can issue that capias again to have you bound and held until we have the hearing, and you will be ordered to get those documents probably before you're released. So it's very important that you look for those documents. If you do not have those documents, if there's something missing, then you must provide a full explanation, not only to Mr. Sullivan, but to the court as well. So I'm kept in the loop of what's going on. Mr. Sullivan, what else are you asking of the court?
I was going to ask that in addition to, and perhaps this is the way to handle this, is to include this when I file a copy of the original order. In addition to those sort of blanket requests, I thought it might be helpful to include more specific document requests that would kind of come up as we're discussing, as I'm questioning Mr. Wilson today, if that's something that Your Honor is comfortable with.
Yes.
Okay.
I mean, if there are documents that you,
It's sort of belt and suspenders, because I think everything specific that I would ask for is already covered within the sort of blanket requests previously, but however you prefer to handle that.
that's fine. Go meet with Mr. Wilson, and you can go in our Zoom room, attorney room, and go over the information. If you believe that there are other documents that you're going to need, and you want to place that on the record, we can get back on the record. But I can let you know, I have to leave early today for a track meet.
Understood. Okay. I guess one other thing to address before we get started, Your Honor, is I think I misunderstood. I didn't arrange for a court reporter to be here to take notes of our examination. If it's okay with Mr. Wilson, I would suggest that, just so that my own notes are not the only record, if I could just record audio on my cell phone that I have with me, if there's no objection from Mr. Wilson to that.
Mr. Wilson, you would be able to request a copy of that as well, and he would have to provide it.
Oh, I agree.
Okay, he
Okay.
agrees. That makes sense. All right, anything further from you, Mr. Sullivan?
Not right now. No, Your Honor.
Okay, thank you. Mr. Wilson,
Yes, ma'am. You asked Mr. Sullivan if he could explain other things that he wanted from me, information. He hasn't provided that explanation to you yet. Further, do you think that I need an attorney with me when I talk to Mr. Sullivan?
do I know? It's not for me to say, that's for you to say. And the fact is you have a capias to be here for this exam, and you're not getting out of it. Sorry. So you're going to do the exam here today.
Okay.
And I believe Mr. Sullivan came from Madison, Milwaukee, down south.
Milwaukee, yes.
So
Well, I think we both traveled today, so.
you came from, what place is that? The little road place not far from St. Croix County. So
Yes, that place.
yeah, I have a cousin that lives there, and now I can't even remember the name of that place. So, all right, so go meet, go see, go do. And Mr. Sullivan, so you know, for the next time, I ordered it to be here and I would swear him in, but my court reporters for me today, I don't have a court reporter.
Understood.
So
I got in touch with the clerk's office, and I think we miscommunicated. So I should have arranged to have our own person with us. So I apologize for that, but I think we'll be just fine.
okay, sounds good. All right, thank you. Then you can go on out, and if there's a clerk there, they can help you. Well, there will be a clerk there. They can help you, or Danny can help you go find the room, and then we'll go from there.
Thank you very much.
Thank you, Your Honor.
Thank you. We will go on the record in the matter 26 CF42, State of Wisconsin versus Scott Lang. The state appears through District Attorney Kevin Schmidt in person. Mr. Lang appears by video conferencing in custody in Burnett County Jail. We're set today in this matter for a bond modification request. However, the criminal complaint has now been filed. I am reviewing his past cases because I believe he may have had a court-appointed attorney. He may not qualify for public defender. Yes, he had a court-appointed attorney at one time. I believe he owns the property that he resides at. Mr. Lang, is that all accurate?
Yes.
And so are we in victims' rights compliance? Yes, Your Honor. Thank you. The court has received and reviewed a bond modification request from Mr. Lang, has received and reviewed a bond modification request or in support of by the victim in this matter. Mr. Lang, what is it that you would like the court to know or to hear as it relates to bond? Currently, you are set at a $500 cash bond with certain conditions such as no contact with RL, SN, or TN or the residents.
That my wife and I need to communicate.
I heard
I
my
mean-
wife and I, that's all I
Yeah.
heard.
That my wife and I need to communicate. We need to, we have a life. Can't just shut our life off.
Well, you can't just allegedly act in the ways that were in the probable cause statement. Otherwise, there are repercussions, and the repercussions here happen to be a cash bond with certain conditions, which is a no contact with victims RL, SN, and TN.
Even my wife, and she's not requesting that this even take
Yep.
place. How you can just shut man and wife off?
I can with certain conditions, and one would be you would need to take a domestic violence course through restorative justice. And she would need to take a class through CRA, and Miss Vicky Bauer can instruct her as to how to complete that. But yes, I can.
Well, I think it's,
My job is the protection of the public. She is a victim in this case. I have to look at that, and that's why the bond is set the way the bond is set, and that's why there's certain conditions. This is not the first allegation of her being in front of this court for certain similar things.
for
So
her,
why would you need contact? Why are you
for her-
asking for contact?
for her to be in front of this is the first time she's ever been in front of this court. She didn't ask to be for any charges. She didn't say she got assaulted. She ain't gonna say she's a victim. Burnett County is though. It was an argument. We're stressed out because we're being targeted by radical people. We just want to get the hell out of here, man. I
Mr.
can't hear
Schmidt,
you.
I'm not talking to you now. I'm asking the state.
I don't have a strong position on this. As the court's aware, he was on probation for violating a restraining order. DOC served him with revocation papers, so no matter what, he's going to be in jail for a while, at least until a revocation hearing if he challenges it. So contact through the monitored jail lines is of less danger to the victim than, him actually being out.
All right, so revocation papers have been filed, so he is going to be in custody. The court I can amend bond so that you can have phone contact while you are in custody that is monitored. But in order to have physical contact upon release, I would need both you and she to go through the class. These are serious allegations. But yes, phone contact is fine. Are you going to apply for an attorney, Mr. Lang?
No, I will seek my own.
All right, we need to get this matter set for an initial appearance. Well, I guess it is on May 6th at 2 o'clock. May 6th at 2 o'clock, it's set for an initial appearance. The court will modify the bond to allow you to have telephone, verbal contact with your wife. And then We'll see what's happening with the revocation and we'll go from there.
Okay.
Thank you. We're adjourned.
That wraps up another complex day in the Wisconsin court system. We saw Shane Cook benefit from deep community roots, Tyler Wilson faced the threat of perjury for his lack of preparation, and Scott Lang navigate the strict boundaries of domestic violence bond conditions. These cases highlight the delicate balance judges must strike between rehabilitation, community safety, and the rigid letter of the law. Lang's case especially shows that even when a victim isn't pushing for charges, the state can and will intervene for public protection. What's your opinion on this case? Do you think the judge's decision was fair, or too harsh considering the circumstances? If you found these courtroom moments as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns right here on channel name. Your engagement helps us keep bringing you the truth behind the gavel.